I should say I haven't done physics for a very long time, so calling me a physicist is a little bit deceptive, although I do have a degree in it. Let me start with a very brief sketch of the history. Iceland was settled by the Norse starting in 870. There is some evidence that there were Irish monks there before that, but if so, they prudently left. The legal system I'll be discussing got set up in 930. There were some changes in it over the rest of the century. In 1000, Iceland converted to Christianity with toleration for private but not public pagan worship. That conversion was by an arbitrated settlement. The arbitrator was in fact pagan, and the conflicts before it killed a handful of people. But by the standards of most places that went from paganism to Christian, it was a pretty peaceful event. Starting around 1200, the system started breaking down with increased levels of violence, though probably not very high by our standards. And in 1263, well, in 1262, 3/4 of Iceland, 3 of the 4 quarters voted to turn the country over to the King of Norway, and in 1263, the North Quarter, I think, agreed, and that's really the end of the story that I'm telling. Our sources for it, the most interesting sources are the sagas. The Icelandic saga. Iceland, I think, is arguably one of the most productive societies in history on a per capita basis of literature. That is to say, you're talking about a population of maybe 70,000 people in a far corner of the world who produced, I would guess, easily a dozen books that are currently in print in English translations. Say a small to medium-sized suburb a very long time ago. The sagas are readable stories. There are really 2 groups of them: the family sagas, which are set in the 1st century or so, a little longer than that, but were not written down until about the 13th century, and the Sturlung sagas, which are set in the period when they were written down. They describe the period of breakdown in the 13th century, and they were written by people who were participants. And that matters because one of the problems is, to what extent can you trust the sagas for a description of things? And you aren't sure for the ones that were written several hundred years later, but you're pretty sure for the ones that were contemporary. We also have 2 surviving legal texts from the very end, one of them from just before the end of the period, and one of them from just after. They don't always agree with the sagas. I have a chapter in my book, Legal Systems Very Different from Ours, which I believe is I think I have a link to it webbed on my webpage, which I've got over there, discussing the various apparently inconsistencies between them and how I resolve them. And also we have archaeological evidence, but that's what I'm working on. The legal system of Iceland had laws. It had a legislature that made laws. It had a court system for settling disputes, but there was no executive arm of government. That is to say, there was no government official in charge of either prosecuting people or enforcing verdicts. Once you got your verdict, it was up to you and your friends to enforce it. And that, in a sense, I sometimes refer to it as a semi-stateless society, in that you had some of the institutions we associate with government, but nothing like all of them. How does it work? The structure of the system depended on a set of people called gothi is singular, gothar is plural, who seem to have originally been pagan priests, but ended up with what's essentially a legal role. There were initially 36, and I think eventually 42 after some changes in the 1st century or so. And being a gothi was property right. You could sell your githord, which was the right to be a gothi, to somebody else. You could leave it to your son. You could even subdivide it, have 2 people agree to take turns in who exercised the rights. What was it? One of the things it was 1 seat in the Logreta, in the legislature. The other and more important thing was that it was the way in which ordinary Icelanders plugged into the legal system. So that being the thingman of a particular gothi was like being the citizen of a US state, say. Which meant that if somebody wanted to sue you, the first thing he had to do was to ask you whose githord you were in, because that would determine what court he could sue you in. There was a series of courts, starting with the courts for clusters of 3 Githord, all the way up to the 5th court, which was for disputes between people from different quarters of Iceland. There were the quarter courts were the main ones where things got settled. At a court had 36 judges. They use the term judges, but it's really closer to jurymen. In everything except the 5th court, the rule was that you could have no more than 6 dissents in order to get a verdict. At the 5th court, it was by majority rule. So most cases are settled out of court. People have done calculations going through the sagas and such, and it looks like about 90% of cases were settled out of court. The basic logic of the system is that if somebody wrongs you, you find out what Githord he is in, you summon him to a case, which is either, well, typically in one of the quarter courts at the Althing. The Althing is the annual assembly at which each Gothi is supposed to come with, I forget what fraction of his thingmen. The only tax in the system is that the members, the term Githord is also used for the set of thingmen of a single Gothi, and those who don't go to the Althing are supposed to contribute to the expenses of those who do. All of this is bargained. That is, you can freely choose at least any Gothi in your quarter of Iceland, and maybe, under some circumstances, Gothar elsewhere in Iceland. And any terms between the Gothi and his thingmen are basically bargain terms. You can change from one to another, but I think there's one day, or at least one period each year, when you can officially make that change. One of the interesting questions for any such system is what keeps it stable. And obviously you have to worry about the possibility that a feud will develop in which each side thinks he's on the right, and therefore each side tries to kill people on the other side or sue people on the other side. There's, I think, a 19th century author who comments that it's amazing they had such an elaborate legal system for people whose chief hobby was killing each other. But he was wrong. Their chief hobby was suing each other, and they only needed an occasional killing to keep the lawsuits going. I exaggerate a little bit. But there's at least some truth to that. One of the interesting things about the system is the distinction between killing and murder. If you are a good law-abiding Icelander and you just happen to kill somebody, you are obliged to go to the nearest house which does not contain people who are relatives of the guy you killed and therefore will kill you if you tell them. Announce the fact. I am so-and-so, I just killed so-and-so, I name the following wounds which I'm responsible for, he's lying over there, goodbye. At which point, of course, then his kin can start taking legal action to ask for damages or to try to get you outlawed. The normal payment for a killing is called weregeld, that's man gold, and it was a sizable amount of money. Why does it matter? If you are a murderer, aside from the fact that that's a shameful thing to be, but if you're a murderer, then all claims of forfeit immunity, all claims that your killing him was legitimate, for example, self-defense, or even that he was an outlaw who was legal to kill, those vanish if you did not announce that you did it. So similarly, there is a large difference between, I'm not sure what the terms are, but basically in a sense, robbing somebody and stealing from someone. That, you know, Vikings engaged in a certain amount of enterprise, but if you're a respectable Icelander and you happen to have grabbed something from somebody, you announce the fact, so he can then sue you and try to get back at you. So one effect of all of this was that you don't really see in the sagas much, if any, disagreement about the facts of a case. That the disagreement is always about the legal status, that a good lawyer will try to argue that for one reason or another, some part of the procedure is illegitimate. There's a famous case in Njal Saga where somebody who doesn't have a good defense, who is himself a Gothi, quietly transfers his Githord to, I think, his brother, becomes the thingman of another Gothi in a different quarter of Iceland. And then when they sue him, countersues for the fact they have illegally sued him in the wrong court. So that's sort of an example of the kind of thing that you get in the sagas, where people are trying to use legal trickery, but they aren't. I can't remember any case in the saga where somebody said, no, I didn't kill him. That's always settled, and that makes it a good deal easier to do the system. It also means that you don't require quite as high a punishment, because if you have a system where you only catch one guy out of 5, then you've got to have, as it were, a 5-fold punishment so that it won't be worth his while stealing, killing, or whatever. Whereas if you have a system where you know that you're going to get caught, so to speak, because you're announcing the fact, that makes it easier to make that work. What happens if I get out, if I get a verdict against me, I'm supposed to pay some money to somebody and I don't? I get outlawed. Once I am outlawed, it is legal to kill me and illegal to defend me or even to feed me or provide me housing. Typically, if I have any sense, I get out of Iceland at that point. The lesser outlawry, the outlawry goes away in 3 years. The greater outlawry, it doesn't. At least we don't know of any. I don't think there are any cases. I think I've seen one thing suggesting that 20 years would do it, but if so, nobody made it, at least that we know of. The part of what's impressive in the sagas is the fact that people always assume that ultimately they're going to be bound by the law. So there's a case in one of the Sturlung sagas, which are the point when things are breaking down, you're having substantial sized battles with maybe 50 people on a side instead of the 4 people on a side that you get in ordinary saga things. And it is still assumed that you're going to have to pay for people you killed. There's one quite neat scene where, if I remember correctly, one side has attacked the house and ending up burning the house and killing some people inside it. And they agree to pay Weregeld. But they say, we won't pay Weregeld for so-and-so because we offered to let him out. We offered to pay him to come out, and he didn't. So we're not responsible. And in the family sagas, it's very clear. There's a line by Gunnar in Njál's saga where he says, where they've been attacked, they've killed a bunch of attackers. The question is, do they pursue the rest of the attackers? They run away. It's Gunnar and his brother, who are both very able, and Gunnar says, no, we'll be out of, our purses will be empty when we've paid for all the people we've killed. And I should say that's a disagreement between the Gragas and the sagas, because by Gragas, those people should have fallen with forfeit immunity because they attacked Gunnar. He didn't attack them. But at least in the sagas, that doesn't usually seem to happen. What if I and my friends insist on fighting back and defending the outlaw? The problem with doing that is that a group of people who are being lawful are fighting a group of people who are unlawful. If anybody gets hurt on this side, he now has a legal claim against somebody on that side, and his relatives are going to join in that claim. So if you try to break the law, the coalition against you expands, and therefore it in fact doesn't pay until, I would say, by Sturlung's period that's probably not true, but at least before Sturlung period it's pretty clear. There's another neat scene in Njál's saga where you've got a court case which it looks as though it's going to break down into violence in the open air courtroom, which is where the whole thing is held. And, well, it's not a courtroom, it's a piece of land. Somebody on one side asks somebody who is friendly but not part of their coalition, what will you do to help us? And he says, here's what I'll do. I'll drop my men over there, which blocks the best place for them retreating to. And if you're winning, I'll break up the fight before you kill more men than you can afford. So it's really quite a neat system. One of the problems with the feud system, I should say I have a chapter in the legal systems book on feud systems in general and sort of the logic of them, is how do you protect the weak people? What if I'm somebody who doesn't have strong sons who went a Viking, and I don't have friends and relatives who will fight for me, and I know that if I try to sue you who just killed my son, I'll get beaten up on the way to the courthouse. And the Icelandic solution to that is that claims are marketable. So I go to my other neighbor who has 4 strong sons who went a Viking in their youth and lots of friends and allies. And I say, how do you like to prosecute this case for me? There's 200 ounces of silver for it when you win the case. And if he's generous, he may agree to do it and to give me the weregeld. If he's not generous, he may keep the weregeld. But either way, the guy who committed a crime against me has gotten prosecuted, and that's a reason not to commit crimes even against weak people. That's sort of one of the standard problems that you have to solve in a feud system, is having some way. And I've argued that making tort claims marketable is a great idea. We ought to do it too. You can think of contexts where somebody damages your car and you don't know how to find a good lawyer and you're not a lawyer yourself. Well, all you do is you just auction off the claim, and whoever pays you the highest will do the best job of enforcing it. So I like to say this is a respect in which the American legal system is a mere 1,000 years behind the cutting edge of legal technology. And I assume the Irish legal system too, though at present, I don't know now. How do you terminate feuds? Well, first, the fact that there's a court makes it less likely that you'll have a feud in the first place, because it means that everybody knows who has what legal obligations. Now, you can still have one in the sense that I can pay my damages, as it were, and then I'm mad at you, and so somebody else gets killed, and it goes back and forth. There's again in Njal saga, which is one of the better known sagas, there's a famous series of killings in which what's going on is that you have 2 women who hate each other and their husbands are very good friends. And so somebody is killed, the relevant husband pays the weregeld, his wife gets somebody to kill the person who killed her person, that husband pays the weregeld, and you've got one bag of silver going back and forth for, I don't know, maybe 4 killings or 5 killings or so. That's fairly unusual, but it's not impossible. One way of terminating is by accepting the legal judgment. One way is an out-of-court settlement, because people don't like to be in a situation where they and their relatives are getting killed. And one fairly common way is arbitration. So you find somebody who is regarded as a trustworthy person, who is himself powerful. You get him to agree to arbitrate your dispute, and you both agree to accept his arbitration. If he arbitrates against you, you can go along without looking like a wimp, because you've got the arbitrator's verdict. And if he arbitrates against you and you don't go along, you've just acquired a new enemy on the other side. So that worked pretty well. Why did it break down? It isn't clear, but what seems to be happening is that in the late period, the power is becoming more concentrated, so that you will have a single family which owns a bunch of Githord, rather than 42 Githord owned by 42 different people. And that means there's less competition, more a position where you can say, well, if you live in this area, you'd better be one of our thingmen, and if we do something you don't like, tough luck. So it did eventually break down. Why power becomes more concentrated isn't entirely clear. It might be related to the conversion to Christianity, because you got a system where tithes were a sort of equivalent to a tax. Part of the tithes went to the landowner who had donated the land and built the church for a particular church. That gave you revenue sources which people could fight over, so that may be part of it. But the truth is, I don't think we really know. We only know that. On the other hand, it lasted for about 1/3 of a millennium, which is certainly better than the U.S. has managed so far. We had a civil war a good deal bloodier than the Sturlung period in the first century of U.S. history. I think I'm about out of time. I want to listen to this next one because I've got a bunch of questions about Irish law. I have a chapter in the legal systems book on Irish law, but it's a somewhat puzzled chapter because I don't think I understand it well enough for my purposes. Thank you.
Adina Ushla, the Yiv, is Misha Creven Flanagan. You're very welcome tonight. I'm going to be speaking about the early Irish native legal system. Irish people tend to be very close to their culture and history. We love our language. It's still spoken, even though it was very heavily attacked for hundreds of years. You can see it all throughout the city. Our music is listened to all over the world and danced to. And our native sports are just as popular today as they've ever been. But when you ask Irish people about the native laws that existed on this land. There's big gaps in the understanding. Part of the reason why I set up the Brehon Academy in 2013 was to bring awareness to those gaps, because I believe that the study of this native Irish law is so insightful that for us to ignore it is to ignore a very deep part of our own identity. What if I told you that it was once said of Ireland that there is no nation of people under the sun who loves equal and indifferent justice better than the Irish, nor will rest better satisfied with the execution of the law, even if it's against themselves, so that they too can have the benefit and the protection of the law when upon just cause they do desire it. And what if I told you that the man who said that was Sir John Davies, who was the Attorney General for Ireland in the year 1606 to 1619, and if you know your Irish history, you know that they were very significant and formative years in our history, just after the flight of the Earls, just after the collapse of the Gaelic order. A man who was not a friend to the native Irish and not a fan of the Brehon Law, still had this very beautiful thing to say about these people. Fast forward a couple of hundred years, we're now into 1958, we have a barrister, an Irish barrister, writing an article called The Bench and Bar in Ireland. And he's speaking of the Irish irreverence for law now. And he says, this Irish irreverence for law doesn't stem from sympathy with crime or from wrongdoing in general, but from the fact that the Irish, who have a fairly long memory, know that the law in Ireland today is not Irish law. However just it may be, it was once most unjust. It does not command reverence as a native institution, but merely respect as an essential part of the machinery of government. What changed? How did we go from a people who were seen to be the ones who loved justice more than any other nation on earth to the ones who were seen to be irreverent of the law? The first book that I wrote, or read, should I say, about Brehon Law was by Lawrence Ginnell, called The Brehon Laws, a Legal Handbook. It's not the most intellectually rigorous book on this topic, but it is a great introduction. It's very romantic. He's talking about it from this sense of something that has been lost. And he says that the laws of a land are an irrebuttable witness to the character of those people. And so what I want to do in this discussion is frame the rest of the conversation around the conflict of two legal systems. And these two legal systems represent the conflict of two mindsets. Okay? So why are we calling it medieval anarchy? How does that fit into this discussion? Were the Irish anarchists in the Greek sense? Did they aspire to this as a philosophy? No, they did not. They didn't. They were not anarchists as a value. They had plenty of rules. That's how I'm able to sit here and talk to you about them. They had loads of laws, and they had plenty of kings. They had more kings than you needed, okay? Well over 100, and they were often competing with each other. But what I want to focus in on here is a very different mindset about what is power, what is authority, and how is it administered throughout society. To the early Irish, the idea of having a centralized control, a monarch who had the right to issue laws, was an alien concept. So this is where I sit with the anarchic approach to medieval Irish law. It was on how did they view authority. The point is, there was no inherent right to rule. Nobody had the divine right to rule because their daddy was the king or something like this, right? This is a very different thing. And I would argue that this is partly where the main conflict between the two systems actually came from. It wasn't a religious conflict. For 300 years, the Protestant church didn't exist, right? So we have to say, well, why were these two people who were neighbors to each other, right? A lot of things in common, but to this fundamental level that they couldn't connect. So there's a couple of ways I want to focus in on how this was anarchic and to show the difference and why it was so incompatible with the colonial systems, the continental monarchies and so on, which is characterized by centralized control and a divine right to rule. So the areas that I'd like to focus on are the nature of lawmaking, the attitude to where law comes from. How do we deal with crime when there is a wrongdoing in society? And probably the most important, and I hope I have time to go a little deeper into this, is the attitude to land and property and ownership. Okay? So first, with lawmaking. Under the Brehon Law, it was a law of custom well established, not by the law of decree. How does a custom become well established? Well, when people engage in honorable behavior with each other over time, certain practices will arise. These practices then eventually become expectations. The expectation, when it's seen to be good over time, can acquire the force of a law. How? What is the right amount of time? Well, they had it since time immemorial. They had all these beautiful ways of talking about the law. Since time immemorial. But what is that? It's only 90 years. It's like 3 generations. Once the 3rd generation had been born and that custom had been in place since time immemorial. And if it was held to be a good custom, then it would be observed by this group of people, by the Brehons. It would be recorded, they would speak about it, and it would become customary law. So in this sense, you see the Brehon system with its polycentric nature allowed for experimentation in customs, allowed for different variances on how to do things in different communities. Now, as someone who studied law, I know the modern jurist is going to be screaming that that's uncertain. How can I be a lawyer if it's going to be different laws in different places? And that's fine. The Brehons were well aware of this. There was a difference between the Urdas, which was the local custom, and the Cain law, which was the universal law of the land, which I'm sure I don't even have to tell you what that law was. Don't cause harm, don't cause loss, don't cause injury. In that sense, we all agreed what the laws were. But when it came to the actual engagement in different transactions, maybe marriage agreements and so on, that allowed for variance. If we compare this with our counterpart, we have a group of men. If we're lucky, it's a group, and if we're unlucky, it's just one guy who happened to be born to a certain bloodline, to a certain family, who is perceived to be divinely inspired by God to sit down and write laws and put them on the people. How absurd is that when you actually put it on paper? It's absurd, and this is the system that we have inherited and just take for granted and say, that's the best way it can be, it's the only way it can be. One of the things the Bretons had to do, which I really loved, was they had to articulate their judgment based on 2 things, a principle observable in nature and through a form of poetry. And there's plenty of examples I can give of this, but I'm limited for time, but one I would draw your attention to, the first copyright case, as they call it, between St. Finian and St. Columkill. They had an argument over who owned the manuscript. 2 monks, okay, they went to court, and the Brehon, in his wisdom, he looked out and he found a principle in nature that a cow gives birth to a calf. So to every cow its calf. You've probably heard that phrase. Most Irish people are familiar with that phrase, but not necessarily where it comes from. It comes from the Brehon Law. Now the problem was, as beautiful as that judgment was, it couldn't stop these 2 sides from having a war, okay? So I'm not ignorant to the fact that there were some issues with the Brehon Law, especially in terms of enforcement. There was no enforcement. There was nobody there who was enacting the will of the judge or the king. There was no cops, guards, to enforce this. So you have to say, how was it self-executing? Why would people follow law that wasn't forced upon them? So making this distinction between the kind of fiat legal system, which I'm saying is the centralized system, a system of control and centralized decree, versus this more kind of holistic system, where the judgment was more important than the person giving the judgment. The title given to you by the crown of the King's Court bench or whatever was not as relevant as the person who could really find the true judgment. I'll try and give you a very quick story. There's a longer version on my YouTube channel if you want to look at it. It's the story of how King Cormac was recognized. Very short version. There was a woman who had a sheep. The sheep escaped, gets into the crops of the queen, eats the crops. There's been a loss, an obvious loss. It's quantifiable. You can see that there's been a loss, damage has been incurred. She asks her husband to be the judge, which was completely acceptable because the king was expected to have the judgment of a Brehon, or we might say the judgment of King Solomon. It was seen to be a kingly trait to be a good judge. And he said, well, this is obvious. There's a loss of the crops. This woman has a sheep. She should give the sheep as payment for the crops. Makes sense, right? We can all see there's an accountancy has happened there. Maybe there's some restitution has happened. But a young boy hearing this in the crowd said, this is a false judgment. This is not the true judgment. As the fleece grows on the sheep, so does the fleece grow on the land. So surely he should give the fleece of the sheep as payment to restore the crops. Don't deprive the woman of her livelihood. I can see you smiling because you can feel the difference in that, right? Am I right? You can see the difference. Am I getting nods? And did it feel something? That feeling, that's why the Irish love justice better than anybody else. It was something that you could feel, something you could experience. That's what their belief was. It was very tied into who they were as a people, their identity, the honor that you have in society, and the fact that the laws are the irrebuttable witness to the character of the people. So moving on to how did they deal with crime? Okay, there's been a wrongdoing. First, our system, if you haven't studied law, this isn't always obvious. A crime is not when there's a victim, a person. A crime is a crime against society as a whole. Civil law is when it's two individuals, but in criminal law, the state steps in as the prosecutor and the victim and the injured party in the form of a DPP or something. We take this as normal. Can you not see how absurd it is that a third party might step in and say, oh, I'm going to take the offence on behalf of that victim? It is absurd, and it was absurd to the early Irish. There was no way that a third party could step in and claim compensation. Okay, there's a story there with Odamon, and it did come in through the church, but that's a little bit more technical than I want to get into. How did they define a crime in Brehon Law? Very simple. It was a lapse in the standards of personal honour and brotherly kindness. A lapse in the standards of personal honour and brotherly kindness. That was your crime. And then the degree of malice and so on was taken into account, like as Dr. Friedman was saying, it's very similar to how they dealt with wrongdoing in Iceland. But the point was that they were trying to resolve the issue. They were trying to find a harmonious rebalancing in the society. And that might sound kind of hippy-dippy and 70s stuff, but what's the alternative? You have an adversarial system right now where families are broken in those courts and never to speak again because it's not made to be amicable. It's not made to resolve the real healing that needs to be done within the family. The Brehons were willing to do the difficult calculations that we don't tend to do so much today. And what I mean by that is they took account of so many things, such as the honour price of the individual, the circumstances that led them to that place. Usually the Brehon would be somebody who would have some awareness or knowledge of the people involved, so they're not completely strangers to each other. I liken this to Richard Posner's much more recent economic analysis of law from the Chicago School. And he was like making these kind of discoveries that all law is economic and all crimes can be based on economics, which is what the Brehons were doing thousands of years beforehand. I was going to tell you the story of Setanta and Cuchulainn and how he got his name, but I'm sure most people probably know that story. I want to give you a story that emphasizes the restitution, the spirit of restitution in Ireland. With Setanta, he killed a dog in self-defense and immediately said, I'm going to be your dog, and he replaced the dog. But there's a better story I'll tell you about the story of Partholon and his wife. So Partholon was one of the early groups of people to come to Ireland. He led them. This is before the Tuatha Dé Danann. We're in mythology, probably didn't exist, but it's in our mythology and has been influential throughout these years. One day Partholon goes out to hunt. He leaves his wife alone at home, and she succumbs to some temptation and decides to bed one of their servants. Now, if that wasn't a big enough insult, they drink from his very special cup. He had a sippy cup, and they drank from that cup. And when he came home and drank from the cup, he knew that the betrayal had happened. And in a fit of rage, what did he do? He killed, not the servant, the dog. He killed the dog. I mean, that's the part where I just stopped liking Partholon, when he killed the dog. The dog's name was Samir. So what happens next? You think this is pre-Christian, thousands of years ago. The woman belongs to the husband, right? He could do what he wants. No, the woman, the wife, summons the king, her husband, to the court. And the judgment is described as a very noble judgment, that it is the right of the wife to recover against the husband. Now, today that's whatever. Back then, this was unthinkable. It was phenomenal how forward-thinking they were in terms of women's rights, property, and their ownership within the marriage. As compensation, he had to restore the loss. He had to give her an island. And to this day, that island is still called Inish Samir, after the dog, and it's up in Donegal. So I was telling you this story to show you, 5 minutes? Perfect. To show you just some of the, to try and give you some of that insight into what was the character of these people who produced this law that is reflective of their ambitions, their aspirations, and the type of society they wanted to have. I'm not looking at it with rose-colored glasses. I could sit here for an hour and tell you all the problems that were in it, but what I'm trying to do is trying to help us Irish people to feel a little bit more of what we lost here, and that there is a lot of value in looking back to the wisdom of our ancestors to try and find at least guidance into the future. I'm not saying we should go back to trading in cattle and stuff, but there's definitely points in here that can give us answers that are not obvious to us in our modern society. So the last thing I want to focus on is the attitude to land and ownership and property. And this is, I think, one of probably the most fundamental parts of the clash of these two legal systems. In the British and continental system, you have primogeniture, which means that the firstborn, usually a male of the family, is the one who inherits everything. In Ireland, we had a system called tanistry, which is where we get the name of our Taoiseach today, right? We call it the Taoiseach from this old custom. And the Taoiseach is basically the second in command. And they would have been elected through the election process during the lifetime of the king. Why? Well, they wanted to avoid disputes in the event of a succession. If you don't have a clear heir, then you have these competing families and they all want their son to be the one. So to avoid the disputes, they would have an agreement beforehand that this is going to be my second in command. This is really important. Title is something that passes down. Title is property. And the English administration could not be successful so long as the title of the land or chieftain would pass to somebody who wasn't continuous. That broken chain where, let's say you're the chieftain of the tribe and I'm the crown, I make a contract with you. The mindset of our people would be like, great, you made a contract with the crown, good for you. How would that bind me? How would that bind the rest of us in our tribe? And this was a problem for the British because they couldn't make one contract with one person and say we now own all. It had to be slowly over time. Two ways to emphasize this. Before I mention that, I would say this is important as well. The Irish knew deep down in their heart that you could never own land. It was something innate in the culture. You could use it for a time being, and then you would go back into the land from when you came from, okay? So this is a very different kind of mindset than what we've inherited, which is the land is to be colonized and taken and take as much of it as possible and put your flag in. We heard in the Icelandic example, monopolies formed as people started to claim ownership of land. Whereas in the contrary system, it was all about how much land you owned and taking it off people. Example of this, first one, surrender and regrant. You probably remember from history school, the surrender and regrant. What was that? Basically, the crown said, just surrender to us your Irish titles, don't be chieftain anymore, don't do tanistry, give us all your lands, and we're going to give it right back to you with a new title. And the title was Earl or something like that. That's a very significant part of our history, and I wish I had more time to go deeper into that, maybe in the questions. Second example is the case of tanistry, which is probably the nail in the coffin of the Gaelic order. It happened in 1608, so right after the Flight of the Earls. You had a land dispute between two different factions. One of them was claiming primogeniture through the English system, and the other one was claiming, through the Irish custom that had been present for thousands of years, succession through tanistry. The courts declared that this custom is repugnant to English law, and that's probably the exact right word, that's the only word that they could have used. What they mean by that is these customs are incompatible with our law. We need people to be in possession. The law abhors property in a vacuum. So there's more that I'd love to go into, but time is tight. Trying to squeeze several thousands of years into 20 minutes is a challenge. I guess I'll just wrap up by saying I have a lot of videos online. I have online courses and so on. If you want to learn more about this, I'd invite you to do that. And just to say thank you to all of you guys for coming out this evening. We didn't know, we thought it might be an empty room. Thanks to John for organising it and Students for Liberty. And a huge Guru Mila Mahagat to David Friedman for the opportunity to share the stage with him. Thank you.
Thanks, Kevin. So we'll open a discussion and...
Yes, I wanted to start first with disagreeing with one thing
I'm not
and
surprised.
then with a question. At the point when the Normans conquered Ireland, which is in the 12th century, there was not an absolute monarchy and wouldn't be an absolute monarchy for at least 400 years. So that your description of the law as a situation where the king could say anything he liked just wasn't true until somewhere around the, say, the late 16th century under the Tudors. The question is, the question really has to do with the anarchy issue, because one of the things that I found very puzzling when I was trying to make sense of this system for my book was that you had one description of a legal system which happened in king's courts, a curial system, and then you had another description of a system that sounded entirely private and decentralized, which involved the distraint system, basically, in which I have a claim against you, I go onto your land, say some things, demand arbitration, and there's a series of events where eventually, if you aren't willing to agree to arbitration, I start seizing your cattle. And that sounded like an anarchist system, whereas the system with a king's court with all sorts of officials in it that was described in detail. So the general puzzle is that we don't, I think, have any equivalent of the sagas, that the Irish equivalent of the sagas are set much earlier. We don't have an equivalent of the law code. What we have are fragments of whatever 11th century or so stuff that get quoted in 16th century sources. So do you have any clear answer to in what sense it was a royal system and in what sense it was a private decentralized system?
Yeah, there's loads that came up as you're talking there. I think, to clarify, we weren't conquered in the 12th century, they invaded, but it took them until the 1600s to actually get the whole island. So, but during that time we had the Pale, which was where we are now, which was areas of Dublin, Wicklow, Kildare and so on, which were for the most part British rule, and they had the enclave. So within those areas you did have British rule acting just as normal. Whereas the Pale, which symbolizes a fence, the Palest fence, outside of that you had us wildlings living their own set of laws. I think that there's a really interesting point, and I've read what you've wrote about this in your book as well, about the curial system and I think you're kind of highlighting one of the features of this system is that there was many different law languages, what they call law languages, that apply to different segments of the society. For example, as a Brehon, I could learn the Fennicus, which was the law of the Fenny, and the Fenny were the free men, the farmers. And you'd make a good living as a Brehon who studied the Fennicus and just taking care of like local affairs and so on. If you were more learned, you would learn the Filiacht, which was the more kind of laws of the nobles a little bit, the poets and so on. And only if you were qualified in that would you be, hearing cases and so on. In the case of the curial courts, the type of people who would be, curial courts being like you go to the king and he's settling it, the cases there would be only really people who are involved in that sphere of society. I don't imagine.
So you're saying only Nemeds would be involved in
exactly, only the Nemeds, which are the noble people.
What's the evidence for that? That's an interesting conjecture, but do we have a way of being sure that it's correct?
Well, you can read into it through the fact that the different law languages exist and they refer to different...
But how do we know that it was the ordinary freemen who used the distraint system and the Nemed who used the curial system?
One of the challenges with the Brehon Law, you've like hit on it yourself, is that a lot of the information is scant, unfortunately. It is fragmented, but by what we do have, it's significant. It's not small little scraps. We don't only have 2 legal manuscripts like Iceland, we have hundreds of them, and many of them remaining untranslated.
Those manuscripts are like 300 pages long.
The Icelandic ones.
Yeah, the 2 versions of Gragos.
So they managed to codify it, and like there's a little bit of kind of
I don't think there's 300 pages or 600 pages of material at least on the early Irish. I don't know what there is on the 16th
I'm not sure,
century.
but I know the Corpus Juris Hibernica is huge. I haven't been able to get through it myself, and most of it is boring and technical and not interesting. It's like how to do the calculations.
And
like
when
how
was that
many
written?
sheep.
When was that written?
Of course,
down?
well, it was reviewed in the last century by Binchi, I believe.
Yeah.
But it's based on earlier manuscripts. So when did the Brehon Law begin, or when were the manuscripts written? We start to have sources from around the 8th, 9th century. Okay, little, and as you say,
but the sources are fragments in 16th century texts, I think.
They appear later in later manuscripts. How we know they're older is by the language that's used in it, by the linguistic, like it's such old Irish, which is another one of the challenges of studying Brehon Law, is the fact that it's actually written in a language that like most of us don't even understand. So I admit that there's like a lot that is being inferred into it. But how I answer this problem of the gaps of the knowledge, the Irish, and so on, is by trying to take a more holistic view of Ireland as a whole. For example, using the sagas as an example in Iceland, I do that with the mythology. We don't have a perfect picture, and the fact that we don't have a perfect picture is a reminder kind of our history, right? There's a reason why we don't have a codified legal system. There's a reason why we have a gap in our cultural record of literature and art and so on that's purely Gaelic. There's an obvious historical reason for that.
I guess some other points where it seemed to me you had somewhat rose-colored glasses for the system. As I understand it, there was no legal protection outside your own tuath, that is your own kingdom, which was a few thousand people. So in that sense, furthermore, as I understand it, somebody with a higher honor price could overswear somebody with a lower honor price, and that again does not sound like a good system for getting justice for the weak. Is that correct?
So on the issue of your status within your tuath, so status was based on people that you knew, it was based on your reputation. It is true that when you left your tuath, nobody knows you, your status would diminish. Not the case that you wouldn't have any legal protection. There was even such...
If you were a poet, you had legal protection, but I don't think there were very many other
But you could still
categories.
have legal protection as an adyarad, which was an outsider. And the duty in that case is on the tuath to protect travelers. Right, so if I'm going through your tuath as a foreigner and nobody knows me and there's a crime committed against me, the liable party was the whole tuath, even as an outsider. So it's not exactly...
So in what court do I sue the whole tuath?
You would call a local Brehon and say, I had a crime committed against me here. And I think you mentioned, if not tonight, but I might have read it in your book, the fact that a secret crime was a very shameful thing. That was a bigger thing. So same situation there. If somebody came to the community and were mugged, let's say, nobody knows who done it, but then if the second liability falls to the whole community, then they're going to figure out who did it really quick, right? Like, who stole from that guy? I'm not going to be paying, like, they're going to find out. I describe that as one of the ways that they kind of had a self-enforcement mechanism. But you're right, your status was based on knowledge. And if you went somewhere that nobody knew you, what would usually happen is what you should do is go to someone who had status in the society, in that community, the chieftain's son or something, and say, hey, like, I'm in town, can I get your okay to be here? Now what would happen, you'd be operating under their social insurance. If you committed a wrong, it would be considered a wrong against their honor, and vice versa, you would have to compensate if you did something on their behalf. So yeah, you didn't carry your status with you unless you mentioned it, learned. Not soldiers, but the literati, the poets and the educated ones could travel through the country and keep their status. Most people actually did lose their status when they moved to a different community, yeah.
Yes. I had another one where, now I've lost it. Actually, one point you might have, not really relevant to all of this, but relevant to some other things I've looked at. The legal rules seem to apply that a woman knew when her fertile period was, because one of the sources of damage payment was that due to what had been done to her husband, she had not been able to conceive that time. Do we, in fact, this is interesting because the question, I've seen it claimed that the rhythm method did not work until relatively recently because people didn't have reliable information on when women were fertile. And this seems to imply that the Irish very early did. And I was wondering if you'd come across any evidence on that.
That's a level of detail I haven't gone into. But I would say, like, on the idea of, like, women in childbirth and maternity and so on, there is some, like, added legal weight in that situation. Like,
But when you say added legal weight, my understanding is a woman could not testify except in those cases where women had special knowledge.
yeah, that's what I understand.
So that's a respect in which it's not what you would think of as rights of women in
That's
modern
true,
sense.
and I wish I had more time to explain how
The sense in which it was rights of women was that the rights within the marriage depended on who had contributed how much to the marriage, so that you could have a marriage on woman's property, in which case the woman had certain rights which otherwise the husband would have.
So let me just add to that a little bit. So this is, to me, how I interpret this was ancient social welfare. Society was hard, okay? If people weren't being protected, they were going to be exploited. And there was these social mechanisms in place, which were one of them. If you're a man, you got to take care of your woman. If you're a son, you're taking care of your mother. If it's a father, it was part of the expectation as a man. So women would act in society upon the status of their closest male until, now this didn't happen as often as it might sound, but a woman could raise her own status. If she became an accomplished poet or a craftsperson or a doctor, which we have records of in the accounts, in the mythologies and the manuscripts. If her status was greater than that of her husband's, well, guess what? She's no longer operating under his status in society. She's operating on her own. That kind of makes sense. Like, we're going to look after you until you're better than us, and then you're on your own, right? So it's also, you know, there's the risk, and I'm sure you've experienced this, of trying to look back from our modern vantage point and to project like values and so on onto the past. It's always challenging. I tried to find like, why did these things happen, and I tried to find like altruistic reasons, like that there's beneficial reasons for it, even if we don't like some of the results of that today.
A couple of other things. First, I believe a woman had half her husband's honor price, and I think a son also. But the other thing is, you were talking about property ownership, and my understanding is that you mostly don't have private ownership of property, that mostly the property belongs to the kin group, the Derbfin, I can't pronounce it, but Derbfin is what,
that's
is
not
what
bad,
it looks like.
And
That so you've got essentially a group of kinsmen who are apportioning out the property temporarily, and under some circumstances somebody can own property himself, but mostly you don't really have private property.
So yeah, that's mostly right. Like, there was 5 types of land ownership in Ireland. All land was seen innately to be fintiu, which was the Dela Finna, the word Finna, fintiu is the land of the clan. And that's kind of, think of it like, I like to think of the Irish family as like a company, and they're an incorporated company. We're all the shareholders. Here's our bit of stock, and you're entitled to a bit of that share if you're a member of the clan.
And do we know what the decision rules were for the Derbfin? Because I don't.
I don't know exactly how it was reapportioned, and that's really interesting. Like, I've thought about that a lot. But here's an interesting one you would like. When the land, there was private ownership. It could happen, but it only happened in certain, like the Nemed, the higher classes, when they had established ownership since time immemorial, like so long. But on a kind of more cultural level, there was an understanding that they didn't own the land, but they had this right. Now, when a wealthy landowner died, and they had 4 sons, and they had to divide that land up between the 4 sons, there's a beautiful way that they did it in Brehon Law. They had the youngest son divide the land up into 4 equal portions, but he was the last to pick. So you had to make sure, right, that whatever way he divided up that land. Who remembers being a kid and having this half a Snickers bar or a Mars bar? You remember that? And you used to go, okay, I'll half it, and you pick, and it would be a hair's line. So this is, I like this example as the type of self-enforcing mechanisms to try and bring fairness that didn't have the council of land apportion coming in and like deciding who should get what. So yeah, you're right, it was more of a communal aspect to land. And maybe as a modern anarcho-capitalist we could shun that, but if anybody in this room is trying to buy a house, right, you can understand that having a little bit of land put aside from you, like just an acre would have been a nice way to start off your life. Coupled with that, there was the expectation of this saying, is fair chuinned, which is a man is better than his birth. So you start off, you get your little bit, that's you can sustain yourself. But if you want to stand out in your tribe, if you want to be a man of like status and have a great family and be remembered, you needed to increase your wealth. And if you did it to a certain degree, and that was measured, if you had this much wealth, for 3 generations, you weren't a farmer anymore, you're the lord. And I didn't mention that in my talk. That's a huge difference. It wasn't the king going like, oh, thanks for the favor, now you're Lord of Ponty, whatever. Right? It wasn't giving out these titles like sweets. You earned your status. You earned that right to be called a lord because it was self-evident by your stature, by the wealth that you had, and so on.
Sorry, gents, can I just check whether you have any audience questions at this point?
Yes, we should.
The gentleman here.
Could I ask, this is actually an addition to David's point, which is this. I think, okay, so what you had before the arrival of the Normans in 1066 is you had systems, the system operating in Ireland, the system operating in Anglo-Saxon Britain was actually very similar, right?
That's true.
And this survived more or less for a century. So what happened was, and this actually occurs just the time, when Henry II basically appropriated to the King of England himself the courts, right? But what he didn't appropriate was lawmaking. Lawmaking, we associate lawmaking with Parliament, but the purpose of Parliament in England was never originally a matter for making laws, except incidentally. It was a matter for negotiating settlements between the king's demand for money for military purposes and its apportionment among the people who had to bear the burden. It's not until the 17th century, and of course it explodes in what was known as the English Civil War, as we prefer to call it, the War of Three Kingdoms, and so on. So at the time that Sir John Davies was writing, in the early 17th century, the divergence between the system of law in operation in Ireland and the system of operation of law in England, you can't call it Britain, okay, Britain doesn't exist.
That's true.
So, is not complete. It's not as it is now. It would have differed in the sense, in the curial way, where the courts were, because those were, that was a royal prerogative. And the whole purpose, by the way, was, and you'll be shocked to hear this, was to make sure you got the money. you got fees for it, right? That's how it worked. It was revenue rich, and Henry II, like any other ruler, was very keen.
But the courts were largely held by nobles as a revenue source.
Oh, yeah, indeed. But here's the other thing. I mean, it's not until the arrival of the Tudors, and not until the accession of Henry VII in 1485 after Bosworth, that you have the end of a system of where the King of England was simply primus inter pares, first among equals. I mean, in fact, at the Battle of Bosworth, so you had the hugely powerful families, the Nevilles, the Stanleys, the Percys, and in fact, it was the intervention of the Stanleys at the Battle of Bosworth which turned the tide in Henry's favour. They actually betrayed Richard III in that one. So it's not until 1485 that you begin to see a change where the landowners lose their independence, they lose their ability to raise their own armies, their own forces, and so on and so forth. So the situation in the 16th century wasn't as dramatically different as it would become, for example, in the 19th century, when parliamentary ascendancy and power had been asserted and ratified after the English Civil War and
So,
the Restoration.
if I can jump, what comes to mind when you're speaking is this period in the 1300s, Edward III, I think, Statutes of Kilkenny.
Yeah, it didn't work.
Right. That suggests to me, just for some context, Statutes of Kilkenny were enacted by the King to his Anglo-Norman lords in Ireland, saying, guys, stop speaking Irish words, stop wearing your hair long. I swear it says that. Don't ride your horses without saddles. And the biggest crime was don't go to the Brehon for judgment. Is what you're suggesting here is that this is more to do with money than to do with ideology of we don't want you going to the Brehons because that's not how we make law, because you're suggesting that they weren't making law that way at the time.
No, in fact, the common law, sorry, I don't want to dominate this, but the common law traditions were, in fact, even until very recently, in the common law systems, right, where there was no statute. Statutes are a recent invention, by the way. The whole idea of making law is an extraordinarily revolutionary idea, not a good one, by the way. But we come back to that. But the whole point is, the judges, as they said it themselves, found the law.
Yeah, they discover it, right?
Yeah, they discover. And now you might say, well, they're just making up as they went along. But the answer is no, because what they're doing is they're looking at the traditions which arise largely from disputes. We're talking about civil law for the most part. And again, it's not until the courts come into existence that you have a distinction between criminal and civil and so on. I mean, one of the things I discovered came shocking when I started reading Roman law for the first time. I started looking for the criminal law, and it's almost non-existent. Okay, it's almost all civil law, and that is the way law developed. So yeah, so the differences. I'm not saying there are no differences. I'm saying the differences are great. And in other words, you control the courts when monies and fines are paid, even if the whole of it doesn't devolve to the king and the royal courts. A lot of it disappears, as you might imagine. It's like taxation.
It was interesting. The Latin word for the bench is bank, right? It means bank. So
Yeah.
that's all I'll say to that.
Are there other questions? Other people? Yeah.
Yeah, so, medieval Iceland, there was 7,000 people in total.
60 or 1,000 or so.
60,000, yeah. But it was so sparsely populated, so I'm just wondering what kind of lessons can we learn nowadays in a more, bigger metro.
Yes. There have been a fair number of feud societies, but there aren't any that are modern developed societies. I should say there's at least one feud society that currently exists in England, or at least did a few decades ago, and that's the Romany. The Romanchal, which are the main Romany group in England, apparently are what I like to describe as a primitive version of the Icelandic legal system, without formal laws and legislature, with customary law, but a system in which what basically controls conflicts among themselves is the threat of violence, where the essential element is that the other people in society know who's in the right and who's in the wrong, and your friends will back you if you're in the right and not the wrong. But no, I don't think we know how such a system would work in a modern society. And I spent about a third of my first book trying to sketch out, before I knew about all of this stuff, trying to sketch out a plausible economic analysis of how a system in which rights enforcement was private and decentralized would work in a modern society. And there's a link to the third edition of the book as a PDF on my webpage, and I've got the webpage URL there. But I don't know for certain whether I'm right. I don't think we can. But there's no particular reason why it couldn't. That for example, to take one example we have in the modern society, that part of the issue is if you have a conflict between two people who have different rights enforcement agencies, will they fight or will they arbitrate? And you in fact have a large-scale model of that at present in the relation between auto insurance companies. That if my car runs into your car, my insurance company would like it to be your fault, your insurance company would like it to be my fault. They almost never go to court. Going to court in that case is the equivalent of fighting each other. It's the expensive way of resolving it. But in fact, they've got rules of thumb, arbitration rules, which it's in the interest of both companies to follow, because this is going to be a repeat interaction many times going both ways. So we do have some evidence for something that says that we're an analog of the rights enforcement system, that you get the result that I would have predicted, namely that firms find that fighting each other is really expensive way of going bankrupt, and that it makes a whole lot more sense to arbitrate instead. But I don't have an example of a modern developed society that works this way, I'm afraid.
Any questions for anyone who hasn't spoken yet?
Quick one that would be remiss, I think, if we didn't, you having raised the subject of the Romany in England, there is a separate community of Irish people, the Irish traveller community in Ireland, 30,000 people, and there's an awful lot of that sort of ritual violence. Are there good sources on the legal system of the travellers? I don't know. It's not a special subject of mine, but it would make our news on occasion that a feud is taking place in a particular part of the country, and it's been. I don't know their internal systems, and my understanding is probably nobody outside of their community really has much of an insight into it.
That would be very interesting.
Wanted to mention it, but the main point I wanted to make, just back, you sparked me off when you mentioned special knowledge that might be that Irish women might have had with respect to medical properties. And I was immediately thinking of St. Bridget and the Irish tradition of holy women specifically, and of course we know Brede predates Christianity, and we're back into the mix of legend and history, but there's certainly a tradition here of a special knowledge specifically for women, by women, that goes back a long time.
And of course, one of her miracles that confirmed her as a saint was that she performed an abortion.
Right.
So does Brehon Law have any special status to confer upon abbots and abbesses?
Well, I think that, of course, the church was very strong in the country for years, and you mentioned these, how do you say this name in the Icelandic system, the people who were like priests who became...
Gothi.
Gothi sound a lot to me like druids. And the druids would become later the legal people. But just on the idea of like special knowledge of women in Ireland, Youre itself, the country is named Youre after the goddess of sovereignty, which symbolized the land. And in order to be a king, it was very, again, we could spend another hour on this, it was a very beautiful ceremony where in order to be a king, you had to submit to the land, which was the goddess, which was a woman. And they performed this kind of ceremonial wedding of the physical man of the king to this sovereignty of the land. So it's very much, I think there's lots more we could talk about of the role of women in society throughout Irish history, but we'd also be remiss to suggest that it was easy.
Women could be weapons, right? That was, how unusual was that?
Very unusual.
Yeah.
And druids and doctors. I mean, so unusual to the point that I can't tell you any stories about particular ones from manuscripts, but you might hear the word banliag, ban being a woman, or bandri, a female druid or a female doctor, and it's kind of in passing. So it doesn't seem to be like very highly valued or something. Just, yeah. They weren't restricted from doing it, but like it was probably easier not to.
And are the sources unpolluted from some unfortunate Christian Catholic, I don't want to say misogyny, but prejudice that might have crept in later, but
I mean,
would have downplayed women's power?
Show me any history from 1,000 years ago, right? That isn't like that, right?
Yeah,
So,
yeah, sure.
yeah.
Okay, we might have to wrap up. Gentlemen, do you have any closing comments that you'd like to add?
I guess my comment is still that I'm not sure I adequately understand the Irish system.
Okay,
You
well,
people should have kept better records.
I will answer to that and say Ireland exists in a liminal space, and we're kind of dreamy, and it's good that you are not fully certain, because neither are we.
I guess the one other thing I would want to say is that my reaction to your claim that the English didn't conquer Ireland until the 16th century is that I think it is true in a cultural sense, but not true in a political sense. That is to say, I think that under Henry II, there were no Irish rulers in a position to fight the Norman lords who were claiming things.
We're going to have
but
an
what is
interesting
true,
dinner conversation.
But what is true is that the Norman the Norman lords in Ireland got gradually culturally absorbed by the Irish system.
That's true. At some point, yeah.
You can continue this conversation.
Yes,
in
at dinner.
restaurants.
Right.
Thank you.
Thank you.